It is clear from the discussion made herein above that the said case was not one relating to compounding of offence. Apart from that, the court found that the dues of the banks have been satisfied by receiving the money, and the suit filed by the bank in the civil court have been compromised. The FIRs were filed in 1987 to 1988, and the investigation had not been completed till 1991. On those facts, the court rendering the judgment in July 1996 felt that having regard to the lapse of time and also having regard to the fact that there is a compromise decree satisfying the bank's dues, there is no purpose in allowing the criminal prosecution to proceed. On this consideration, this court held the provision of Section 482 of Criminal Procedure Code. In the facts of that case, the learned judges held that the bank filed suits for recovery of the dues on account of grant of credit facility, and the suits have been compromised on receiving the payments from the company concerned. The learned court held it an offence of cheating in prima facie constituted. Such offence is a compoundable offence, and compromise decrees passed in the suits instituted by the banks for all intents and purposes amount to compounding of the offence of cheating. In that case, the court came to the conclusion, since the claims of the banks have been satisfied and the suits instituted by the banks have been compromised on receiving payments, the court felt that the complaint should not be perused any further, and therefore the decision of the High Court in quashing the complaint does not require any interference under Article 136 of the Constitution. It is therefore clear that no legal proposition has been laid down on the compounding of offence in Duncan's Agro. This court proceeded on the peculiar facts of the case discussed above. Therefore, the said decision cannot be an authority to contend that by mere sanctioning of a scheme, the offences committed by the appellant company prior to the scheme stand automatically compounded. Reliance was also placed on the decision of this court in the case of CBI New Delhi, reported in 5 SCC 257. In that case, reliance was placed on the decision of this court in Duncan's Agro as such. The court found that the aforesaid scheme, being a voluntary scheme introduced by the Government of India before the trial court and filed separate applications under Order 37 Rule 3 of the Code of Civil Procedure for permission to defend the suit. The defendant's application were based on a number of grounds, but we may only advert to the one that seems to have weighed with the High Court. It was contended on behalf of the respondents that since the plaintiff appellant had got a promissory note executed in its favor by the borrower, defendant number 1, and had further made the borrower create a equitable mortgage in its favor by deposit of title deeds, they would be absolved of their liability in terms of Section 139 of the Contract Act. According to the respondents, their plea gave rise to a tribal issue, and they accordingly sought permission to file their written statements and contest the suit. The trial court, by its judgment and order, examined all the pleas, including the ones based on Section 139 of the Contract Act, and held that none of the pleas raised by the defendants gave rise to any substantial defense against the claim of the plaintiff. Accordingly, it dismissed the petitions filed by the defendants respondents by order dated and proceeded to decree the suit of the appellant plaintiff for a sum of rupees 4 lakh along with cost and expense and future interest at 10% per annum on the decreal amount from the date of filing of the suit till the date of realization. In appeal, the Delhi High Court, as noted above, set aside the order and decree passed by the trial court and directed it to allow the defendants respondents to file their written statement and proceed to try the suit from that stage. The High Court noted that relying upon Section 139 of the Contract Act, a contention was raised by the respondents that the recovery of its loan from defendant number 1, the principal borrower, the plaintiff should have taken recourse first by either seeking to give effect to the promissory note or by enforcing the equitable mortgage. Neither of these remedies, which were open to the plaintiff, were taken recourse to, and the recovery was sought to be made straight away from the appellants. The High Court further held that the trial judge fell into error in holding that Section 139 of the Contract Act had no application to the facts of the case. According to the High Court, this was beyond the scope of deciding an application for leave.